Chapter 12, Using and Choosing Trademark Counsel. I get asked all the time, can I file a trademark application by myself? The simple answer is yes, no attorney is necessary. But just because you can does not mean that you should. Of course, I recognize that my position is biased since I've helped clients obtain more than 3,000 trademark registrations. An excerpt from a 2011 piece in the Wall Street Journal by Peter Blunt captures many of the reasons doing everything on one's own is not always best, even though the article has nothing to do with trademarks. The article is called "Do It Yourself, Do It Poorly?" ? And I'm quoting from it now. The real problem with, say, do-it-yourself wedding photography is that the photos look like they were taken with Aunt Julia's cell phone, because they were. We teach ourselves Spanish on the internet and then wonder why we can't even order a taco. I think this is a perfect description for the situation with using counsel for trademarks. By attempting to register a trademark without counsel, a business may create more problems than it began with, may incur more expenses than it would have by hiring a professional from the start, and may increase its risk of litigation. The following are some good questions that business owners should ask of any prospective trademark lawyer. How much experience do you have working in the field of trademarks? 1 year, 5 years, 10 years, more? Does your practice handle other types of cases, or is it focused exclusively on trademarks? A generalist may be valuable for some things, but probably not for the complex trademark registration process. Have you ever worked for the United States Patent and Trademark Office? Inside experience can't hurt, of course. What are your fees? How much are they, and how are they calculated and structured? Are they hourly or are they flat? What do your fees for a trademark application include? What happens, for example, if the USPTO requires more information or initially rejects the application? Are there additional charges for necessary follow-ups or responses? How do you keep abreast of developments in the field of trademark law? Are you active in associations? Have you attended or given CLE, continuing legal education, trademark programs in the last year? How many registered trademarks do you or your law firm own? Do you practice what you preach? How do you keep track of deadlines with USPTO for your clients? Do you use special or custom software? How many trademarks have you registered over the years for your clients? More than 10, more than 100, more than 1,000? How large is your staff? Do you use paralegals or outsourced contractors to work on your clients' trademark applications? Or do you personally handle and supervise all of the work on a client's application? What types of content have you created and shared so that the public can learn more about your work and your trademark experience? Do you blog, write articles, create videos, write books or podcasts? How many hearings have you handled before the Trademark Trial and Appeal Board? The Trademark Trial and Appeal Board is a reviewing administrative court of the USPTO, and they interpret most of the laws and regulations that the USPTO trademark examiners must use. So those are about 10 or so questions that I recommend you might want to think about asking potential trademark counsel before you hire them. And as we said at the outset of the chapter, hiring trademark counsel is a great decision. It may end up saving you money and saving you time on the very important journey of protecting your trademark.